All right, today we are diving into a case that really gets at the heart of what assault means. We're going to break down Cullison versus Medley and see how a threat, just a threat, can turn into a full-blown tort, even if no one ever lays a finger on you. So, here's the big question this case really puts in front of us. Can a threat by itself actually be an assault, even if you're never physically touched? Where's that line between just scary words and something you can actually sue over? Let's dig in and figure it out. Okay, so here's how we're going to tackle this. We'll walk through the confrontation, the legal question, the rule of assault, how it's applied, the court's final call, and of course, your key takeaway. We're using the fire rack method here. It's a super useful way to analyze pretty much any case. All right, first up, the confrontation. Let's get into the legally significant facts. What actually happened here that kicked off this whole legal mess? So check out this timeline. On February 2nd, 1986, everything just explodes. It starts with Dan Cullison inviting a teenager, Sandy Medley, for a Coke. Seems innocent enough, right? Well, just a few hours later, her entire family shows up at his mobile home. And that's when things get intense. They surround him, they threaten him, and it all leads to some serious physical and psychological distress for Cullison. Now, you've got to pay attention to this quote right here. Ernest Medley, the father, threatened to jump a straddle of Cullison. I know, it's kind of weird phrasing, but this isn't just some throwaway line. This very specific threat became a huge piece of evidence. The court had to figure out, was this a real, immediate threat of harm? And look, the court was smart about this. They didn't just zero in on that one threat. They looked at the whole picture, the entire vibe of intimidation the Medleys created. Put yourself in Cullison's shoes for a second. There are 5 people packed into your dark living room. The dad, Ernest, has a revolver in a holster, and he keeps grabbing for it while he's threatening you. Then you've got the mom, Doris, with her hand stuck in her pocket. What's in there? You don't know. And on top of all that, Sandy's calling you a pervert. It's the combination of all these things that really builds that sense of fear. Okay, so that's what happened. Now let's get to the I in FRAC, the issue. What was the exact legal question the court had to wrestle with? So here it is. Could what the Medleys did actually count as an assault, which would mean the lower court was wrong to just throw the case out? See, the trial court had already dismissed it, basically saying, nope, not an assault, case closed. But the question for the Supreme Court wasn't, hey, was this an assault? It was, could a jury reasonably look at all these facts and decide it was an assault? That's our really important difference. So to figure that out, you need a rule, right? Let's look at the R in FRAC, the rule of assault. What does the law actually say? Okay, here's the definition, and it comes from the Restatement of Torts, which is a huge deal in this area of law. An assault is an act where you intend to cause harmful or offensive contact, or, and this is the big one for our case, an imminent apprehension of that contact. So you don't actually have to plan on hitting someone. Just making them think you're about to is enough. That second part is everything here. And I love this quote the court brought up from a really old case. Assault is a touching of the mind, if not of the body. Wow, that just nails it, doesn't it? It perfectly explains why assault is about protecting your mental peace, your freedom from fear. This is the legal foundation that lets Cullison argue he was assaulted, even though he was never physically touched. So if you break it down, here are the boxes Cullison has to check to prove assault. First, there has to be an act by the defendant. Second, they had to intend to make him afraid of a battery. Third, Cullison's fear has to be reasonable and of an imminent battery, like it's about to happen right now. And finally, the tort is complete once that mental peace is shattered. That's the whole shebang. Okay, now for the main event, the A in FRAC, the analysis. This is where the magic happens. We're going to see how the court took those rules and applied to the absolute chaos of what happened in Cullison's trailer. First up, the court looked at intent. And they basically said, come on, a jury could totally look at what the Medleys did, showing up in a group, surrounding him, with one of them packing a gun, and conclude that, yeah, they probably intended to scare the daylights out of him. And this is a really critical point. The Medleys argued, hey, the gun never even left the holster. But the court wasn't buying it. They said the combination of that holstered revolver, Ernest repeatedly grabbing for it, and all the verbal threats, that was the whole package. That was enough to create the threat. So that leads us to the next big question. Was Cullison's fear of being shot reasonable? It's not enough that he was terrified. The law has this test. Would a normal, reasonable person in that exact same spot also be afraid? And the court's answer here is so important for how our legal system works. They said, you know what? That's a question for the jury. A judge can't just decide what's reasonable from their bench. Figuring that out is exactly what juries are for. It's their job to step into the situation and make that call.
So, after all that analysis, what was the final call? The C in FERAC. Let's see what the court decided.
And boom, the Supreme Court said the trial court made a mistake throwing this case out. They reversed the decision. This doesn't mean Cullison automatically won, but it means he had enough evidence that a jury should get to hear his story and decide. So the case was sent back down to continue. All right, let's wrap this up. What is the one big thing you absolutely need to remember from Cullison versus Medley? What's your key takeaway? Here it is, plain and simple. The core of assault is the fear, the apprehension of getting hit, not the hit itself. You don't have to be touched. The weapon doesn't have to be pointing at your head. When you mix threatening words with menacing actions, like reaching for a holstered gun over and over, that's enough. That can be an assault. And just to make sure this all sticks, I'll leave you with this to think about. What if the Medleys had shown up without a gun? Would just their words and the fact that they surrounded him be enough to create a reasonable fear of an imminent battery? Really chew on that one, because figuring that out is how you'll really master the lesson from this case.